Unfortunately, there's not just one lawsuit. There are two lawsuits. There's a lawsuit that's been filed in Waterbury by 5 specific plaintiffs in this case, 5 individuals. And it's Eris et al. Versus Region 14 et al. The thing to keep in mind is this: that lawsuit that's been filed in Waterbury has not just been filed against Region 14. It's been filed against John, against Jody, and against you, George. Not only that, it's been filed against the towns. Both the town of Woodbury is being sued, and the town of Bethlehem is being sued. And that's not all. Gerald Stomsky is being sued. So is Jeff Hamill being sued. So I'm not a math major, but that's a lot of defendants being sued. Now, in this lawsuit, they're not just simply saying declare the election null and void, which, I don't see the need for the lawsuit on any regard. They're seeking monetary and punitive damages from all the individual defendants and from the district. They're seeking attorney's fees. They're seeking money. We have to defend ourselves. Look, when someone's sued, especially when they're suing you, claiming you're engaged in some grand conspiracy, you have to defend yourself. Otherwise, look, let me just be honest, they're seeking money, not just a do-over election. We have several times, the towns have asked the parties in Waterbury, look, there's a lawsuit up in Litchfield over the same issue. The cases were filed about the same time. We're not, for whatever reason, neither parties knew about the other lawsuit taking place. We found out about it, frankly, the same sheriff that served us, I think, then told the towns, oh, by the way, another lawsuit is being filed. We found out from the sheriffs the next day. But they were invited. We were told in August, the town's attorney for the town of Woodbury said to the attorney for the area, the 5 plaintiffs, look, there's this lawsuit up in Litchfield. Just join it. Just come up here. It's a simple case. We can resolve it. They have declined that offer. I filed a motion to stay the lawsuit in Waterbury. I basically said, look, there's a case up in Litchfield. Let's have that case in Litchfield heard first. Not to do anything more in Waterbury. And that's the way it should be, because I was of the position that the Litchfield case would be a relatively simple case and a very quick case. And I had the fear that the case in Waterbury would be a morass. I hate to say I told you so, but on that count I was right. As I said, in Litchfield we went to court one time for the trial. It lasted 1 hour. I've been to court already 4 times in the Waterbury case for, several hours. And basically we're discussing the shape of the table. To put it in the closest terms possible. I thought several times in that case the judge was trying to get us to work out a path forward procedurally. And what the judge was recommending, frankly, this is on the record, was what I had proposed, which is, go up to Litchfield if you want. If you want to make any arguments, go ahead. Just, put this on ice. We weren't asking for the plaintiff to give their case away in Waterbury. I think, frankly, it should be dismissed. But we weren't saying, give up your right. We were simply saying, look, just let the case in Litchfield take place. They've refused that. We've been to court 4 times. The last time I was in court in Waterbury last week, it was, let's put it this way, when we were in court in Litchfield, I felt some degree of pride for the legal profession. Because the attorneys there, I thought, maybe not were doing an incredible job putting the case on, with respect for each side. We were advocating with some vehemence for our side. Obviously, I've taken a position that's different than the town attorneys in that case. But we're doing it with respect, and with the process, and respect for the courts. I think that's important to proceed that way in light of all of this. My concern, frankly, with the parties in Waterbury is that's not been the case. When I was in Waterbury, the last time there was some strange allegations about some grand conspiracy, and maybe my hearing is not working as well as it used to be, but there was even an allusion to somehow the Litchfield court and Judge Pickard was part of this whole conspiracy. Look, before Judge Pickard several, many times, and unfortunately many times for this district. He's ruled for me. He's ruled against me. He may rule against me in this case, for all I know. I have nothing but the greatest respect for him. And to have to listen to this kind of attacks, at that moment I felt ashamed for the legal profession. Embarrassed to be a lawyer, to have to listen to this stuff. That's what's happening in Waterbury right now, as we speak. This whole, there's motions being filed, memorandum on issues that are really ridiculous. I mean, the case in Waterbury, I'm trying to keep it calm here, but the case in Waterbury has claims of constitutional conspiracies, claims that I didn't know existed. There's even a claim against the parties in the Waterbury case of violations of the Connecticut Unfair Trade Practices Act. When did you folks get involved in trade or commerce? When did you start making money? I mean, that act's applicability is, and frankly, it's disturbing that this is even part of a case on a referendum. We had a simple case here about a referendum. Was there notice properly given? Was it not given? Is the election valid? That's what's happening in Litchfield. I think we're done in Litchfield. What's happening in Waterbury is, I think, frankly, unnecessary. It's costing the district money, time, and energy. But let's also remember, it's also costing the towns time, money, and energy, because the town has to defend themselves. So does both towns and their officials. My hope is that still, when the Litchfield case comes out, the decision comes out, maybe there may be some closure of this process. That's the thing we all want to have. If the court in Litchfield rules in favor of the district, our hope would be we can proceed with the project as is. If the court rules against the district, such is life. There's no guarantees in life. If the court rules against the district and says we don't, even though there was no effect on the election by this violation, I don't think anyone can claim there was an effect on this alleged violation. You have to do it over again? Fine, you know it. And we can tell the people voting for this project, look, we have to do this. Simply as we could tell the people if the vote is, the decision's in our favor, look, this is a valid election. That's all we want to have an answer. That's the only thing we wanted in this entire process, was a quick, clean response to this question. And the people in the district deserve that. Any questions?